Welcome again, everyone, to the University of New Mexico Law and Mental Health Didactic Series. This is a series hosted by the University of New Mexico Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Services Division. I'm Anthony Perillo, the Forensic Psychology Training Director in the Department of Psychiatry and Behavioral Sciences at the University of New Mexico. For our talk today, make sure that you, if you have any questions, we're happy to ask those at the end of the webinar. You can enter those in the Q&A box down at the bottom of your Zoom link anytime you feel comfortable. Again, we will reserve those till the end. We don't get to all of them, but we will do the best we can. For those that are seeking continuing education credits, you do have to stay for the full hour, but don't have to stay longer than that. I'll try to let you know when the hour has passed. For those that are pursuing medical education credits, there will be a sign-in sheet in the chat box very briefly. And for APA continuing education credits, the link will be posted again in the chat box in about the last 5 minutes or so of the webinar. Now, for that, you want to open that link before you leave the webinar. And you want to save the certificate that you get after that yourselves. We don't have access to those continuing education certificates. The recording and a PowerPoint for this presentation will be available within the week. And as a heads up for next week, we will be talking with Drs. Jeff Youngren and Jana Martin, who will be discussing liability and risk management.
We seem to have lost Anthony. We will just give it one more second and see if he rejoins us, and then we will continue. Thanks so much. Okay, Daniel, why don't you go ahead? Oh, you are. Okay. Thanks, Anthony.
I apologize for that. I don't know what happened there. Did some of my intro to Dan come through?
I don't think, but I think that's okay. I think, I'd ask for a brief, I'd suggest that we be brief, and that was brief.
I'm happy to do that. Yes. All right. I will throw it your way, Dan.
All right. Thanks so much, Anthony. I'm sorry about that. All right. So I'm Daniel Murrie. I'm based at the University of Virginia. I'm happy to be back with you all again. I continue to think these webinars are such a nice service to the field, and I have been grateful to Julie previously and Anthony now, and always Alex for facilitating these. I really know how much people value these and find them useful, and I hope not to break that good streak today because these have been a great service. I'm going to be talking about forensic mental health evaluations in capital cases, particularly mitigation evaluations, and I will do all of this early kind of paperwork briefly. I think you know about the CEUs, you know about the disclosure. I'm not speaking for University of New Mexico, nor am I having financial conflicts. You will see your learning objectives here and in the evaluations. I'll let you know that much of what I'm covering on mitigation evaluations is really fleshed out better in a chapter in this text that I wrote with Dave DiMatteo, Natalie and Michael, gosh, maybe a decade ago now. That will have much more detail. And of course, that process has shaped my thinking on this, and I've benefited from the good work of these colleagues in this project. And while I'm speaking about books, I really want to commend a few others to you. Mark Cunningham, of course, has done more and better work than anyone on capital case evaluations, and his book in this Oxford Best Practice series, like all the others in this series, is a really nice, succinct, easy to read, helpful guide for people sort of getting into this work or referencing if they've been doing this work quite a bit. It's a great resource. And more broadly than just evaluations, for those of you who are interested in the death penalty in America, a particularly good recent book is by Brandon Garrett here, who was a colleague at the UVA Law School here, now at Duke, has done some really good work on the declining death penalty in America. And this is a particularly nice summary of some pieces of that. But I will not be talking about the death penalty broadly. I'll be talking about this very narrow practice of mitigation evaluations, pre-sentencing evaluations of mitigation at capital sentencing. And this is such niche specialized work. You know, it's about as niche and narrow as you can get. In fact, it's irrelevant in most states, right? Most states don't have this because there is no death penalty. But it is the sort of the deep end of forensic work. And I think there's principles here that of course are relevant to other types of evaluations. And so we'll cover these and try to flesh out some of those principles. Now, like any kind of evaluation, these capital mitigation evaluations have a particular legal history. This is particularly rooted in our country's brief moratorium on the death penalty, where there was a pause because Georgia's death penalty was ruled unconstitutional as applied then. The court then basically had a choice of how to handle the great amount of discretion and sort of arbitrary application of the death penalty in that era, and ultimately settled on a strategy that was to reduce discretion to guide sentencing in a more individualized way, right? The goal was to consider aggravating and mitigating principles to sort of individualize the decision. And so in the modern era, what we have in most death penalty states is an arrangement that, bifurcates the trial into a guilt phase and a sentencing phase. The sentencing really requires this particularized decision. Just committing a capital murder is not enough to warrant execution. There really has to be a consideration of whether there are reasons not to execute. That is, whether there is mitigation that would bode for a sentence less than death. And since then, there is a pretty rich legal history that fleshes this out and that maintains that the jury has every right to consider any information that might bode for a sentence less than death, anything that might be mitigating. And you will see some very, very broad definitions of mitigation. Any aspect of a defendant's character or record or any of the circumstances of the offense that the defendant puts forward as a basis for a sentence less than death. That is mitigation. So it's almost tautological. What's mitigation? Well, anything that might be mitigating. And the Supreme Court has emphasized that the defense team should always have opportunity to present almost anything that might be mitigating. This is really a hallmark of capital sentencing. And you'll notice some of the language around mitigation is just remarkable. So this is one of my favorite quotes, and it's just almost poetic. Here the court describes mitigation as any of the diverse frailties of humankind. And you think about this compared to like the Dusky standard, or maybe the standard for legal insanity in your state. And this is just such different, broad, poetic language. This mitigation, you'll hear me say again and again, is so broad. As an example, here is Texas statute, Texas being sort of the country's #1 fan of the death penalty. And even Texas describes mitigation in the broadest terms. The jury is to take into consideration all of the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant. Again, that's not a term we as psychologists use a lot, but it will come up frequently in this niche. The personal moral culpability of the defendant to warrant a sentence of life imprisonment without parole rather than a death sentence. Here you'll see the Virginia statute governing the contents of a pre-sentence mitigation evaluation. Now, actually, the statute no longer exists. Virginia has recently ended the death penalty, but I still really like this statute as kind of an illustration or exemplar for mitigation evaluations in general. So there's instructions in the old Virginia statute to consider these first two prongs here, which are something like a light version of the insanity defense. Mitigation in the actual act of the offense. But this third prong also, and look how broad this is, whether there are any other factors in mitigation related to the history or the character of the defendant or the defendant's mental condition at the time of the offense. And this is so intentionally broad. That's everything. And many states will have sort of this third catch-all category for mitigation. So something like this is usually the referral question, and it often includes this broad catch-all clause. And of course, we know our goal, our job in all forensic evaluations is to answer the referral question, right? The referral question always determines the focus of the evaluation and the content of our report. We offer a complete answer to that question, but we also limit discussion of information that does not bear directly on the question at hand. We do not answer what we are not asked. And frankly, this is where I think people, evaluators and legal professionals, can get really confused with mitigation evaluations. And that's one thing I want to emphasize throughout this talk. I'll emphasize it again in a moment. What are implications then if the scope of mitigation is this broad? What are we to do? Well, we're to think of this in sort of a unique way, right? Mitigation questions are unusually broad because the scope of mitigation is boundless, right? It could be anything. If this was sort of a different workshop, we might stop here and generate examples. And it could be anything in the defendant's history. Usually we think of adverse experiences, but it could also be very positive features of the defendant. And even if all 400 of you offered an example, it would be tip of the iceberg, right? There's so much more to go. So it's very, very broad. And at the same time, mitigation questions are unusually narrow because they are answered only with mitigation, not aggravation, not competence, not sanity, not some of the other issues we address. And again, I think this feels really tricky for people. We're seeking a broad range of data that's important because it might be mitigating. We're not just comparing a defendant's capacities to a legal standard. So the scope is just tremendously broad. As this illustration shows, it involves thinking about a person in their many contexts, in their ecosystems, if you will. And our goal is to give a thorough and objective evaluation of the defendant's characteristics, formative experiences, and so on. But also, I would argue, a scientifically based perspective on the ways in which these might be mitigating. So I think there is an approach to mitigation that is just telling sad stories, and there is no doubt that many stories that defendants present with are deeply sad or deeply tragic. But part of our role as psychologists, I would argue, is also to link those to science. Most of these very sad or very adverse experiences have a rich body of scientific literature addressing them, right? We know something about the effects of these experiences, and I'll argue that we want to bring that science to bear in this kind of work. Again, very broadly speaking, mitigating evidence tends to be one of two things. It tends to be either explanatory and contextualizing, and by that I mean it helps to explain how and why the defendant became someone who committed a capital murder. What was the story? How did they come to be in this courtroom? But it can also be counterbalancing, right? We tend to think of the first, sort of telling the story, but it can also be counterbalancing. It sheds light on aspects of the defendants that were not evident in the capital murder. These could be very positive, humanizing features of the defendant that, of course, aren't going to be obvious there in police records or offense accounts. So these are the two broad types of mitigation. And I think evaluators struggle with this. And frankly, my motivation for this talk, I think, comes from doing a lot of habeas work, reviewing prior evaluations and case records at the appeal stage of the death penalty case, and seeing some of the ways in which evaluators have handled this task of mitigation evaluation somewhat strangely. And so, I'm thinking of some examples like a report where an evaluator goes into great detail on the defendant's masturbation habits. Now, this is comprehensive, right? They've got the idea that mitigation is comprehensive, but I don't think they have the idea of mitigation, right? Like what exactly mitigation is, or an evaluation that goes into great detail on the police records of the investigation and the gory details of the offense. And again, offense details may be mitigating, but as a general rule, right, that's not the focus of a mitigation evaluation. The goal isn't to share everything. The goal is to share everything that may be potentially mitigating. So the fact that mitigation is broad doesn't mean everything goes in the report or that everything's included, but it means that we cast a broad net looking for mitigation. Finally, I'll sometimes hear the explanation or the claim that a mitigation evaluation is biased because it only addresses mitigation, that somehow that's a form of bias or almost dishonesty of some sort. It is somehow misleading. But mitigation is actually a legal question, right? Is the legal question prescribed in at least certain state statutes around this. Is what the Supreme Court says must be presented. So there's nothing inherently biased about mitigation, right? It is the referral question in these evaluations. And we don't say that a competence evaluation is biased because it's not addressing sanity. We don't say that a sanity evaluation is biased because it's not addressing violence risk. Our goal is always to address the referral question only, answering it honestly and completely, but not answering other questions that were not asked. And the more I do habeas work, or the more I'm in kind of capital case context, the more I think this is really thorny for us evaluators, and we tend to struggle with this, maybe in ways we don't with other evaluations. And I stress that this duty to objectivity, the duty to minimizing bias, still stands. I feel very strongly about that. The expert has an obligation to address this broad concept of mitigation very objectively and even-handedly, right? It means not stretching findings, not opining beyond what the data can support. It means not speculating. Deviating from objectivity hurts, right? It hurts the cause of justice. It hurts credibility in the work. We still don't do that, but one can address mitigation quite objectively. Mitigation itself is not inherently biased. I want to emphasize. And again, you'll see our guides, our responsibility towards objectivity and fairness here in the SGFP. All right, so with that, let me talk about some of the frameworks and kind of the ways of thinking about mitigation. I would argue that maybe the best framework to start with is this biopsychosocial model, right? The model that that tries to consider everything, right? It takes into account biological, psychological, social, and cultural factors that influence an individual's development and behavior. Now, there's always going to be narrow disciplines that matter in capital litigation, right? It will be very important in many cases to have a neuropsychologist, to have a addictions expert, things like that, biological, medical experts, that sort of thing. But usually for the psychologist, the evaluator, it's crucial to take this broad biopsychosocial approach. That really is going to be a key framework. Other frameworks I tend to argue are helpful, and you know, I want to say that this is not universal. This is my opinion here. One, I really like an emphasis on developmental psychopathology. Not so much as an emphasis in the report, but as a framework for looking at somebody's rich and complex history. Many of you have had classes in developmental psychopathology. You understand it's this rich discipline that really is rooted in a biopsychosocial model and examines an individual's history from many perspectives. It considers concepts like risk factors, protective factors, equifinality. There is no one path that leads to capital murder, and multifinality. Even people who had seemingly similar backgrounds can end up in very different places. Most defendants, you know, don't have all siblings charged with capital murder. Some of their siblings even look like they're doing much better. And this raises all sorts of questions. And I think developmental psychopathology offers an important lens on many of these concepts that are relevant to understanding someone's history. You'll see me click through these slides very rapidly. There's no chance of covering them all in the time we have, but I did leave these slides long and detailed in case maybe they're of use in the future. So I'm you know, hopefully you can bear with me clicking through these fast. I don't expect to truly cover all these, but I do want to leave them here as a resource. The other framework besides developmental psychopathology, which is a discipline, right, that we use in psychology, is this, we'd almost call it a philosophical concept or framework of moral culpability. You saw this referenced earlier in the Texas statute. Moral culpability is the extent to which a person is morally blameworthy for what they did. And, you know, this appears greater to the extent that we've got the resources, capacities, and experiences that allow us to consider a wide range of options. And it's lesser to the extent that we lack the resources, capacities, experiences, and influences to consider a wide range. And I will, for all of this, this moral culpability concept, I will refer you to Mark Cunningham's very, very good work here. You'll see in this text, but in many other places, he really walks through these questions of moral culpability in ways that I think are really, really helpful. And he sort of maps out how we have actually already covered this criminal responsibility at the guilt phase, right? And if somebody was not criminally responsible, we wouldn't even be here at the sentencing phase. And here at the sentencing phase, it really doesn't make sense to review criminal responsibility. Did the person have any choice in what they did, right? If those were at issue, there would have been an insanity defense. There would have been some mens rea discussions. There might not have even been a guilt finding. So in this sentencing phase, addressing moral culpability, we're talking about degrees and influences. We're talking about what shaped choices and behaviors. And this is actually, you know, very much in the purview of psychologists and forensic evaluators. But it's just really important for us and for the system to understand the distinction between these questions and the traditional criminal responsibility questions, right? These moral culpability questions are what actually individualizes consideration at the sentencing phase. And it's not necessarily just making excuses. It's not some sort of scam that defense attorneys cooked up. It really is a concept rooted in statute. And again, I'll kind of refer us back to the Texas statute that is explicit in asking for consideration of personal moral culpability. So what do psychologists do in all this? In this long, messy capital litigation, what do they do and how do they address mitigation? Well, there's several different ways. And before I'll get to those, I'll mention that this context differs because whatever role the psychologist is in, it probably is going to feel a little bit different from other types of litigation. First, many states have capital defender units. Virginia, before we abolished the death penalty here, has some very sophisticated, very experienced, very, very sharp capital defender units. They were teams that only worked on capital cases, usually just 1 or 2 cases at a time, devoted tremendous attention and resources to these. I know that's not true in every state, but it is a feature in many states, and it really is a different kind of context. The second is the mitigation specialist. Psychologists do not always have experience working with these mitigation specialists, but they are remarkably helpful. They are largely investigators. They are part of the defense team. They do so much of the work that we might normally do in a smaller case. But again, they're kind of a feature that's not entirely unique to capital litigation, but more common there. So in this unique context with this unique team, the psychologists can have various roles. Usually they do not have the mitigation specialist role that I just mentioned. That is more often filled by social workers or investigators. They may have other kinds of consulting roles that are not evaluating or testifying, but are helping educate the attorneys in one way or another. That is not uncommon. Another potential role is this teaching expert, teaching about a circumscribed topic, usually a mitigating factor that is complex or poorly understood. And just like in other cases where there can be teaching testimony, here the psychologist or psychiatrist functions as an educator who can summarize research, who can explain complex phenomena in a way that's relevant to the particular defendant, but doesn't necessarily have to have evaluated the defendant. And even in some scenarios, there might not be much emphasis on the case facts. There might just be a discussion of the general effects of fetal alcohol syndrome or a particular addiction or so forth. And again, teaching expert is still bound by our ethical codes to present this research accurately, objectively, acknowledging limitations. But the common role, the one we'll focus on today, the one maybe you all are thinking about, is this evaluating expert. This is the role of performing the evaluation, just like you might do in a competence or sanity evaluation, to examine the defendant and certainly examine all the records and collateral sources, and then providing some kind of opinion. How does this work? What do evaluators do in this context? This too, I will just speed through very, very fast. Obviously, interviews are a key part of this. Not always the most important part. Okay, so a key part, but not necessarily the primary source of information. Probably should not be the primary source of information. Typically require many more interviews. Even a long full day interview, I feel like, is usually not enough in these cases. I usually aim for multiple interviews that would require, that will allow for some rapport, especially discussing sensitive topics, right? So much of mitigation is understanding formative experiences, adverse experiences. Many of those are very, very sensitive, right? And it does require some rapport to get to these. And often there's this kind of back and forth iterative process of meeting with somebody, going out and digging through records, exploring a lead, if you will, and bringing that back to discuss. The alleged offense may be a component of this interview, but not necessarily. That does not have to be the case. And you can imagine all the complexities of this, right? This is pre-trial. Some defendants will be maintaining their innocence at this stage. It may not make sense to interview about the offense, although the offense itself can often be a source of mitigation, and that can come through in records or in other sources. All right. Collateral records are crucial. I cannot overstate the depth and breadth of work on collateral records that are necessary in these evaluations. This this is almost always facilitated by a really good mitigation specialist, right? Who has done this homework, has been doing it for quite some time before an evaluator is even brought into the situation. And they can often be very, very helpful. Kind of collating and presenting these records in the most useful way. Of course, you still have a duty to review these, right? You don't necessarily defer to someone else's review. You want to see these yourself. I think records in a report or testimony are particularly credible and helpful. Often they look like a more objective source than what the defendant has conveyed. Of course, records may or may not be perfectly objective. There's all sorts of ways they can be fallible too. But there's also often some really poignant descriptions in records, from prior teachers or social service workers or things like that, that really convey some important mitigation long before the person was ever facing charges, right? And there is an important credibility to those kinds of accounts. So much emphasis on collateral records, right? They reveal new information that the defendant may have not known. They can really shed light on situations. Collateral interviews are crucial. Third parties are always a part of these evaluations. Even when defendants do not have a rich social network, even when they've burned a lot of bridges, there almost always are people who are worth talking to. And their accounts are often really crucial. I'll say that sometimes in forensic evaluations, there's this idea that defendants are always trying to exaggerate or mislead or things like that, and of course, right, that certainly can happen. But there are many times that records or collateral interviews have, for me, revealed much more mitigation than the defendant themselves was. And there's a number of reasons for this, right? One, defendants may just not have insight into their own history. They may not know about things that happened when they were very young. They also don't have much perspective, right? They sometimes don't know how deeply traumatic or unusual their backgrounds were. And that information may be described richly by a teacher or a social service worker in the records, whereas the defendant themselves would say, well, my life was pretty normal. Sure, nobody, people didn't always get along, but it was very normal. Whereas social services might have described the picture very differently. So, again, no source of information is perfectly reliable or objective. We're always sort of comparing these against one another. But we do want to kind of guard against, assumptions about the credibility of each one, and really try to flesh out the true history based on the weight of the evidence across these very many sources. All right. Testing, there is certainly value to testing, but one of the things we want to emphasize about these capital mitigation evaluations are they're not just like longer general psych evaluations. And again, we'll sometimes see evaluators go into these with just sort of the battery of tests they would use for any general assessment. And that's just not necessarily the appropriate approach. Testing is really determined by the exact referral question, and this sort of, default battery of I give an MMPI and a WACE in every case just does not really serve this referral question very well. There are times where a great deal of testing is relevant. There's times where it's not. Neurocognitive testing is often important. Many defendants have a history of head injuries or other sort of insults that would warrant a good neuropsychological evaluation. But this is not the time to be a generalist and say, oh, I know a little bit about neuropsych. This is really the time to get the best neuropsychologist possible and do a good, thorough neuropsych evaluation if that's really a question. Maybe some screening is in order from an initial evaluator. But this is not a time when one evaluator should be doing everything, and often really problems can arise from an overconfident approach or I'm a good generalist approach. This is really a time to get specialists. And one of the good things about capital litigation, if you will, is that it does allow for thorough work, right? It does allow for getting a good neuropsychologist to do the neuropsych eval, and it does not have some of the constraints that happen in other contexts. And so there is really no excuse for not doing the best and most thorough job here. All right. So I'm going to continue to move rapidly here. The focus of this evaluation should include a very detailed multi-generational family history, a great attention to early development, again, coming through all sorts of sources, not just the defendant's self-report, covering childhood, adolescence, early adulthood, and adulthood. Remember that so much that is mitigating occurs in these early years, early development and childhood, because these are times when what the defendant experiences is not the defendant's fault, right? It's not the product of the defendant's choice. Nobody chooses to be born into a family marked by intergenerational violence and abuse and addiction. Yet this is where many capital defendants started out. And these early adverse experiences are not because they made a bad choice or were taking risky behaviors. This is just the context the child was born in. And this really does have a formative effect, right? And we as social scientists know a great deal about the long-term effects of some of these early experiences. And so, this is a tremendously important area of focus here. We really kind of work our way through the lifespan. We may address the capital offense itself. We may do that with interview, or we may not, depending on any number of factors, all of which require very detailed discussion with counsel. Presenting findings, this too will vary with the nature of the case, the jurisdiction, the attorney's strategy and request, but often there is a formal written report of findings. Occasionally this is very brief, just sort of a brief as possible summary of potential testimony, but many times these are very, very long and detailed. And they, there are often two purposes or strategies here on an attorney's mind when requesting a report. One is, truly seeking the contents that would come out during testimony, truly wanting to understand the case and all the mitigation is there. The second purpose is that these can often be shared well before trial as part of an effort or strategy towards a plea agreement. Here is the defendant we're looking at. Here's a lot of mitigation that's there. Here's what would come out in trial. These reports really seem to vary across evaluators. I don't, of course, know how all of these look, but in doing this work, I noticed that mitigation reports tend to vary a lot more. They tend to be more idiosyncratic than, say, a competence report. In our field, a competence report, even a sanity report, really follows certain conventions, and even when conducted by different evaluators, may have a lot of similarities in how the report is structured. And of course, there's outliers here and there, but by and large, our field has a almost a normal curve of evaluations where they tend to look pretty typical, pretty similar, especially on narrow issues like competence. When we get to these mitigation reports, I noticed they, just anecdotally at least, my impression is they seem to differ quite a bit among evaluators. So it's to really oversimplify and try to be crude, I'll say there seem to be at least two approaches, although many other permutations of these and even other approaches entirely. But one more common one is this kind of broad narrative report, sort of like a life history biographical report, And maybe this will have, more conventional kind of interview and testing sections afterwards, but kind of a lengthy life history that sort of tells the story in considerable detail. And these usually entities should focus on the data that's potentially mitigating. They often include a historical narrative to kind of weave it together in a chronological format. Sometimes these are challenging for evaluators because there's a question about what do we include these other big events that weren't necessarily mitigating? How is other information presented? And those can be sort of, I think, thorny in some ways, even though in a certain sense it's also simpler to just give a narrative history. There's another strategy that's really sort of statute-based, or at least centered on the actual mitigation question. And so something like this might be responsive to whatever the state statute is, addressing the content of a report, or it might just list mitigating findings with some discussion about each. And in a certain way, these can be very, very long and comprehensive also, but in a certain way, this strategy is a little more focused on mitigation. And over the years, I have actually drifted from the former to the latter, right? From starting with just a historical narrative to really saying, no, I'm just going to kind of identify the mitigating themes. And I might put these in historical chronological order, but I'm really just going to identify those without any effort to sort of spell out the whole life history, because that's more of a convention than a true necessity. And so those are the two broad approaches. I think if I can, I'm going to stop and just give you a kind of a quick example of a sanitized report, just to show one approach to doing these. So I have stopped the screen share. I will try to share the screen again here with a sample redacted report. And again, I will share this just as an illustration with no claim that this is the best way or the right way. I welcome any kind of critique of this. But as I struggled over the years to think about how to narrowly address mitigation, how to bring in relevant scientific information, this is what I sort of came upon. And again, I suspect many people can improve upon this, but we do all the things we usually do in reports, right? We address them to the proper recipients. We list all the records we reviewed. We talk about our confidentiality and disclosure. I tend to start with an introduction to mitigation. This may be addressing the state statute. It may be talking a little bit more about mitigation in general, including how the Supreme Court has defined it. But I'll then go into these mitigating themes that are usually in chronological order. And often there is some initial one that really begins before the defendant did, meaning there's something about the intergenerational context that is relevant and mitigating. Not in every single case, but in many, many cases, there is this intergenerational history of family violence or abuse or addiction or instability. And sometimes these are just generations of tragedy, right? Hardship after hardship, abuse after abuse. And so I will try to spell these out, sometimes with bullet points to kind of identify the key pieces. I will sometimes break these into sub-points within a theme. So prenatal exposure to substances and domestic violence. These are things that the defendant experienced in utero, certainly had no control over these, but were potentially quite impactful. While he was in utero, his mother experienced daily beatings and consumed substances daily. That really is significant. And I will try to weave in the relevant research I do this in little gray text boxes, almost like a college textbook might. Again, that is my convention, probably stolen from college textbooks, based on my theory that readers maybe get bored with a lot of dense text. And it was helpful to me to kind of separate it. Here's what happened in the defendant's history. Here's what science tells about those kinds of experiences. I've seen other evaluators do this, in very different ways, maybe with footnotes, maybe just kind of weaving in a narrative about research. I think both of those are totally viable. I've seen lovely ways evaluators have handled that. This is just the convention I have come upon, is describing the experiences and providing some sort of research summary on these, right? Some sort of primer, if you will, on a particular type of adverse experience. And I do, again, I don't think our field yet has strict right or wrong rules about this, but I do think it's important to bring in research on some of this. Like, I do think that adds something, although I would also say there are many, many ways to do this, and mine is not the best way or the only way. But again, we talk through the experiences the person has, we give particular key details or key illustrations or examples, and then provide some research on this. And so this usually follows some kind of chronological order, although some things like abuse, may span many, many years. Addiction may span many, many years. And so these are just, again, these are examples. They sort of move up in time towards the present, ultimately may describe the defendant's condition at present. If there are, symptoms of psychiatric illness in particular, those are described. So again, that is kind of one report convention I have used. There are probably very many other perfectly great ones to use there. Beyond the report, there is sometimes testimony. The good news is that many, many capital cases end in a plea, not a trial. So often you will do extensive work in a report, but not have to testify. But of course, if testimony is required, these are among the most lengthy, intense, and stressful procedures. I argue that people like us are actually not the best people to provide testimony. I prefer to do that as a last resort, because I think so much mitigation can be conveyed better by what we call like a life history witness. Me talking about what a defendant says he experienced, or even what the records say he experienced, is definitely not the same as his sister witnessing this. So again, I think we are often sort of last resort experts. Maybe we are experts who can sort of weave some things together, who at the end can tie together some of the information that other witnesses have provided, and maybe describe the relevant science. But I do not like this idea that the evaluator kind of sums up everything and handles everything. That's really not ideal as far as I'm concerned. I think there's tremendous potential for jurors to misunderstand what we as evaluators are doing here. I think there's tremendous potential for them to misunderstand what mitigation is. And so I will often ask or work with an attorney for some sort of orientation or introduction to what my task is, right? It's not making excuses, it's not minimizing the harm, but it's really kind of fulfilling what the Supreme Court says is required, which is for the jury to hear anything that might be mitigating. Let me stop there, because I think we're getting near the end, and I want to leave a little room for questions. Hopefully not hard questions. But let me stop there and kind of let Anthony take over as the MC.
All right. Well, thanks so much, Dan. as you shared what I think people found very helpful seeing the examples, we got several questions about, hey, would it be possible for us to see a copy of this mitigation example later on in the future? If people email you, I guess, is that there a way that they could see the sample report?
Yeah, so I'm sorry, Anthony, I was looking at these questions as they pop up. The sample report, it's funny, I used to share in workshops, and I noticed I don't share it anymore because there was like some cut and pasting and some, these reports are created case by case, right? So it's not as if, I don't think people should get like sort of an abuse box that they then put in every case, even though there may be some real commonalities, right? Everything is case specific. And so after a while, I kind of came to a position that I don't think I'm going to share sample reports.
Thank you. Someone asked if you could give some examples of the different context you've been given in terms of a mitigation referral question.
Yeah. You said different context, Anthony, is that right?
Yeah, some examples of the referral question.
Yeah, so some are spelled out in statute. So much of what I've done historically had been in Virginia, which really kind of spells out those three criteria, right? There's two mitigation criteria that are related to the offense, and then there's a third that says, is there anything else mitigating, right? And I would say that is the most common, by far the most common scenario in these evaluations, is that kind of broad, tell us anything that might be mitigating. Occasionally attorneys have, well, I shouldn't say occasionally. I mean, there are many times attorneys will kind of slice up some of these tasks and they will say, hey, here's a real trauma expert whose focus is addressing the trauma. But general mitigation expert, could you address, other things? Could you explore what else is there? There's other, very narrow questions at capital sentencing about future, what's sometimes called future dangerousness, which we would call violence risk assessment in a prison context where somebody would be sentenced. There is a whole rich science on those, and again, I refer you to Cunningham's, very, very good work on those. There's a very narrow kind of appropriate way to do those. Atkins, requires its own referral question. Addressing intellectual disability. But often the mitigation questions are very broad.
Could you discuss how a mitigation evaluation would be different if, say, you were retained by a prosecution, say, to counter a defense expert's report?
Yeah, I think that's a great question. And again, this is going to be a little state specific, right? Because I know different states have very different approaches to this. The right answer under the Virginia statute that did exist when there was a death penalty, and the answer I perceive is right, but I understand others will differ, is that an evaluator retained by the prosecution is also retained to look at mitigation, right? They are retained to give a second opinion, objective look at mitigation. They are not retained to drum up aggravation, at least as many states define this. And certain jurisdictions, do this clearly. So for example, military capital trials, very, very rare. But in those contexts, the prosecution's expert cannot interview the defendant, but they give a second opinion on the defense evaluator's work. Is this credible and reasonable, or is this a stretch? In Virginia, where the statute allowed appointment of a prosecution selected evaluator, the question is still that same mitigation question in statute, but it is a second opinion, and I think that's right and good, right? I think the system certainly should have, it's certainly reasonable for both sides to be looking at this. I don't know that I think it's appropriate for a model in which defense is looking for mitigation, prosecution is looking for aggravation. Like, unless the state statute specifically spells that out, I'm not sure that's the role.
How about the if you could speak to the ethics of accepting referrals in these cases when the evaluator has certain moral beliefs about capital sentencing, including the best process for one to consider the appropriateness of accepting or rejecting a referral for capital mitigation?
Yeah, I don't. I think reasonable people disagree on this. I've heard various points. I see that questions from Ivan, and I know he's very thoughtful. I think different people have different perspectives on this. I have heard that somebody who is, maybe if you're against the death penalty, you shouldn't be in this at all. Or maybe you shouldn't. I don't know that there's a right or wrong answer there. At least in a rule of thumb way. I think anything that prevents one from doing an objective job is a barrier, right? So if Dr. Smith's objection to capital punishment at large would lead Dr. Smith to stretch or exaggerate the truth in this case, to assign a diagnosis where it's not really warranted, to bend accuracy in any way, I think that's a problem. But I'm not sure that I have kind of a blanket policy or idea that people with X belief can't do Y evaluation.
Seems like kind of an extension of that, the competence to be executed question that's come up time and time again.
Yeah.
Mm-hmm. To what extent do your recommendations about mitigating factors and the report itself, how would that generalize to other sentencing evaluations that are non-capital in nature?
Yeah, I think a lot will be similar. The trick with capital is there's just such a rich jurisprudence describing this, right? I mean, you saw some of those quotes about the jury has every right to consider everything that might prompt a sentence less than death. And so I think those are teed up so nicely in capital cases. There is case law on what's that speaks to what can be considered in sentencing in non-capital cases. A good legal scholar could tell you much more about that than me. But I think some of these things still apply. I mean, I think there are contexts where you might, summarize here are the factors that had a bearing on the person eventually doing this offense, right? Here's kind of what led here. And I think some of that's reasonable. I think citing research and that kind of pre-sentencing evaluation is certainly reasonable. So I think some of those themes carry through.
How do you document, if you do, if say you attempt to interview collaterals like family members and they fail to cooperate? How would you describe that?
Yeah, I mean, I do describe that much like we all, anytime we do reports and you want some records and they're not in on time, you note that in some way. I certainly do that in these reports. And sometimes that's data in and of itself, right? This person's mother wouldn't cooperate, that means something. So I will note that. There are, again, there's often a mitigation specialist who has done this very good work. And I've at least been fortunate to have many scenarios where a great mitigation specialist has done a lot of the relationship building and then says, hey, Dr. Murrie here would like to talk to you and interview for, and by that point, it's a really good transition and handoff. But yeah, if there's scenarios where somebody doesn't engage or doesn't cooperate, you make good faith efforts, and then I think just convey that.
Someone had a question that did note this thing you're talking about here about prior mitigation specialists that have often done great, thorough job with a lot of these. When they've already done the extensive interviews of family members or other relative informants, do you typically rely on their work for your evaluation, or do you follow up and do your own interviews with those same informants as well?
So I do. So this may be duplicative. It's asking them for more time. I understand there's downsides to it. I don't ever want to be in a position of saying, oh yeah, I know this because the mitigation specialist told me. The mitigation specialist that that's an advocate working with the defense team. They told me that. So they're often, kind of a roadmap. I can tell you he has an aunt, Sarah, who lives here. I've told her to expect a call from you. They may even say, she told me X, Y, and Z when we talked. So that's great to have that sort of roadmap, but I will still review those records and do those interviews myself. One, just because I don't want to be relying on anybody else's word or work product. And then two, because there's often something else that comes out of it, right? There's often some other question that comes to my mind that I want to ask, or some other, lead that we want to investigate. So I'll still do it, even if it's duplicative.
I think this question's a little bit broader than mitigation per se, but I'll go ahead and read what they wrote here. I don't come from a US context, but I was wondering about the feasibility of a sociological approach to reformation to future dangerousness.
Yeah, I don't know. I may not fully be following that. The future dangerousness question, it's a very narrow question about, will this person commit violence in the future? And of course, that future is confined. Life without parole is the option in every state with the death penalty. It's Texas and Oregon that explicitly require this, although other states ask questions that evoke this. So there is kind of a best practice for doing that, and I'd refer you to Cunningham's good work, but it really relies on the base rate data, the known data of violence in prison, particularly among capital offenders. That's kind of the way to answer that.
And then just one final question here. How often would you say diagnosis is part of your work in a mitigation report?
Fairly often. Yeah, I think, historically, psychologists often made the error of, building up to a diagnosis as if it answered everything. Here's your answer, the diagnosis. And in forensic work, we have really evolved, right? We know that's not the answer to the psycho-legal question. We know it doesn't answer whether someone's competent or sane. And the same is true of mitigation, right? Like, some diagnoses are absolutely relevant. Schizophrenia, if there is a clinical diagnosis there, I usually report, describe, explain it, because it's usually relevant to mitigation. Antisocial personality disorder, not particularly relevant to mitigation. Not surprising that any capital defendant, would meet criteria for that, almost by definition. So I don't see that as an answer to the mitigation question. I don't hide that, right? If somebody says, does he meet criteria? Sure, like that's not surprising. But I don't see it as an answer to the mitigation question. But many other conditions absolutely relevant to the mitigation question. Yeah. So, and then Anthony, I see another one here I want to respond to. I actually get the question list popped up. There's one here that says, oh, come on, are you seriously saying that moral culpability can be scientifically assessed? And so, I want to be clear that, I would never say, I know of no one who would say his moral culpability is 70%, or he gets a 9 on the moral culpability scale, right? It's a different phenomenon, right? It is almost a philosophical concept. But so much of what we do is relevant to this legal and philosophical question about moral culpability, right? And this shines through loud and clear in the Supreme Court's Atkins decision, in Roper. The decisions that have narrowed the scope of the death penalty in the US have done so precisely because of moral culpability. Atkins does, it does call for a scientific assessment of IQ, which the Supreme Court says is relevant to moral culpability. Roper, that's an assessment of age. That's not something only we can do. But that's relevant. So yeah, in response to this question, no, there's no, I don't use I can't think of a time I've ever even used the words moral culpability in a report or testimony unless I'm quoting statute. But is that a phenomena or a concept to which our work is relevant and which our work can inform? Yeah, absolutely. I mean, Supreme Court's clear on that. Yeah.
Dan, you're always willing to go the extra mile and help people inform their best practices. So can't thank you enough of once again coming here, sharing your expertise with everybody, and providing some very informative and practical ways for people to understand these kinds of evaluations and things to consider if they do them in the future. Yeah, it's been great seeing you. Great, thankful for you sharing your expertise with everybody.
Well, glad to be here. Thank you all.
Absolutely. That is a wrap for this week's Law and Mental Health series. Hope to see you next week with Drs. Jeff Youngren and Jana Martin. And we will see you next week. Take care.